All right, we're just going to go ahead and get started. My name is Alex Benaroche. I'm a legal associate over here at Levelset. One of my main functions here is to answer questions on what we call the Expert Center. If you're not familiar with what the Expert Center is, it's basically an online forum where people can come in, post any construction payment related issues, and they're answered either internally by our legal team, or we also have a growing community of outside experts from across the country. One of whom we have today. This is going to be David Adelstein. He's a partner over at Kerwin Norris, based down in Florida. And today he's going to be explaining a little bit of the ins and outs of how to make a payment bond claim under the Federal Miller Act. So without further ado, David, why don't you go ahead and take it away?
Thank you, Alex, and thank you, Levelset. As Alex mentioned, my name is David Adelstein. I'm a partner at a law firm in Kerwin Norris that's based in Florida, although our construction practice takes us outside of Florida in many instances. Today, we're going to talk about Miller Act payment bond claims, the Miller Act being a federal statute governing federal construction projects. In light of us only having 25 or 30 minutes, we're going to try to do this as efficiently as possible. During the course of the presentation, if anyone has any questions, you can either ask them here, you can email me directly, call me directly, or post it on the Expert Center at Levelset. This is what we're going to try to go through today. The Miller Act, basically, we're going to talk about the statutory language since the Miller Act is a federal statute. I'm going to show you the statute and then quickly give you kind of the key points that provision is discussing. We're going to talk about claimants under the Miller Act, who is a proper claimant, final furnishing as governed by the Miller Act, subs and privity with the prime contractor, a burden of proof, a claimant's burden of proof to support a Miller Act payment bond claim. Subs or suppliers are those parties not in privity with the prime contractor. The statute of limitations for a Miller Act payment bond claim, along with the venue or the forum to bring a Miller Act payment bond claim. So this is a statute under 40 U.S.C. 3131. The Miller Act is confined in 4 different statutory provisions, 40 U.S.C. 3131 through 40 U.S.C. 3134. The key points of this provision is a Miller Act payment bond, and really we're going to focus on the Miller Act, the payment bond portion of the Miller Act versus a performance bond portion. A Miller Act payment bond is required if a contract is more than $100,000. Many of your federal construction projects are going to be more than $100,000. A Miller Act payment bond will be in the amount of the prime contract, while the contracting officer has certain authority to lower it. I've never seen that actually occur. And then a Miller Act payment bond cannot be less than a performance bond. So if your prime contract is $15 million, you're going to have a payment bond of $15 million and a performance bond of $15 million. Again, this is a statutory provision. Ultimately, there are certain contracts that a payment bond and performance bond does not need to apply to. The first deals with certain military projects, dealing with the Army, Navy, Air Force, or Coast Guard, dealing with assembling vessels, aircraft, or munitions. The second deals with the construction, alteration, or repair of vessels for certain transportation projects. The Miller Act is a remedial statute that's liberally construed. The purpose is to ensure that those who furnish labor and materials for public construction projects will be paid. And because it's a remedial statute, it's going to be liberally construed to effectuate the congressional intent to protect those whose labor and materials go into public projects. So I didn't mention this earlier. As it pertains to the Miller Act, I've represented subcontractors, subcontractors in Miller Act, and suppliers in Miller Act payment bond claims. And I've often represented the prime contractor and its surety in defending those claims. To get a copy of the Miller Act payment bond, I always suggest that parties that enter into federal contracts on the front end request that from the prime contractor or during the course of the work. I have never had a prime contractor refuse to do so, for the very reason that a party can just make that same request to the contracting officer and get a copy of that payment bond. But in the event that doesn't work, there's a mechanism where you can get a certified copy of the bond by filling out executing an affidavit stating that you're a subcontractor supplier on a particular project, sending that to the applicable department, and then they'll give you a certified copy of the bond. If that's the route you're going to take, I suggest you do that sooner than later, i.e. before a dispute actually arises. But again, I've never had a prime contractor or even a contracting officer refuse to send me a copy of the payment bond. This is a chart to show you parties that will have a Miller Act payment bond claim. Your prime contractor or your general contractor is the one that's going to actually furnish the bond. Then you've got your subcontractor and supplier, your first tier. They will have Miller Act payment bond claims. And then you've got your second tier, which are your subs and suppliers hired directly by your sub, will also have Miller Act payment bond claims. No one else will. So third tier subs and suppliers have no rights under a Miller Act payment bond. So if you're hired by a prime contractor, you've got Miller Act payment bond rights. If you're hired by a first tier sub, you're a sub or supplier, you will have Miller Act payment bond rights, and you'll need to preserve them. If you're hired by a second tier sub, you will not have any Miller Act payment bond rights. It's important to know on the front end whether or not you have or do not have a potential claim against the Miller Act payment bond in the event you're not paid. So as I mentioned, the third tier sub with no direct contractual relationship with a first tier sub will have no payment bond rights. In a case out of the Western District of Oklahoma, a second tier sub was simply part of a joint venture of the prime contractor. Of the first tier sub. As a result, a subcontractor that had no relationship with the first tier sub or the general contractor wanted to create the argument that it had Miller Act payment bond rights by turning a second tier sub into the first tier sub based on the relationship between the prime contractor and the first tier sub. And the court was having nothing of the sort. And they said, look, if you're a third tier entity, you've got no rights, period, regardless of the connection between the first tier and the prime contractor, and them being part of the same joint venture. Final furnishing, this is your statute under 40 U.S.C. 3133. In a nutshell, what this says is a Miller Act payment bond lawsuit cannot be initiated until 90 days after a claimant's final furnishing. So if you're owed money and you continue to work, you cannot sue the bond until 90 days after your final furnishing on the project. And there's some authority that if a claimant prematurely files a lawsuit, there's an argument that the lawsuit should be dismissed because it's prematurely filed, but there's a better argument that if a claimant prematurely files a lawsuit, they can simply file a supplemental pleading after 90 days from their final furnishing date to cure that issue versus having the lawsuit dismissed because it was prematurely filed within that 90-day period. A final furnishing date is going to exclude punch list, warranty, or corrective work. So a subcontractor that's correcting their own work can't use that as a basis to extend their requirements under the Miller Act. So you always want to back up your final furnishing date with a daily report showing you're doing base contract work or approved change order work, certified payroll, which will be a requirement under any federal project, or any other payroll type of record to support that there was labor doing work on that particular day. When it comes to suppliers The actual delivery or incorporation of materials is not the driving issue. And the reason why I always bring that up is because that's contrary to some state lien laws or bond requirements where the actual incorporation of the materials is a prerequisite to perfecting a lien or bond claim. Under the Miller Act, what's important is a supplier's good faith belief that the materials were intended for the specified work. So for example, if you're a supplier and you deliver materials to a subcontractor or a project and those materials get siphoned off to another job, I've had this occur, you would still have a Miller Act payment bond claim. And for suppliers, you always want to back things up with invoices and presumably delivery tickets, which signed delivery tickets confirming the delivery. Many times when it comes to a supplier, they'll furnish materials on an open account per credit application. And even when suppliers are furnishing on an open account, they often may have, if it's rental equipment, separate rental agreements based on the type of rental equipment that's actually being furnished. But everything will fall under the same governing credit application by the subcontractor, or perhaps the prime contractor. The supplier's final furnishing will be the last date materials or equipment are furnished to the project, even if there are separate rental agreements. And there was a case where a rental equipment supplier furnishing on an open account did not serve separate notices of non-payment, which I'll discuss in a minute, for each piece of equipment that was furnished under a separate rental agreement. And the court said, look, the supplier doesn't have to serve 10 different notices of non-payment based on 10 different rental agreements for rental equipment served under the same open account. Subs and suppliers in privity with a prime contract, as I mentioned, have Miller Act payment bond rights. However, unlike a second-tier sub, they do not have to serve a notice of non-payment. I repeat, if you're in privity of contract with a prime contractor, you do not have to serve a notice of non-payment, as the prime contractor already knows of your existence. But you still must bring an action after 90 days from your final furnishing date, and as I'll get to in a little bit, within 1 year from your final furnishing. The burden of proof for a Miller Act payment bond claim, regardless of whether you're a first-tier sub or you're a second-tier supplier, is going to be the same. You supplied materials or labor in prosecution of work provided for purposes of the prime contract. You have not been paid. You have a good faith belief that the materials or labor were intended for the specified work under the prime contract. And then the last requirement is you meet the jurisdictional requisites of timely notice, i.e. you timely served your notice of non-payment if you were required to do so, and filing. You timely filed the lawsuit within the statute of limitations, and you served it and you filed the lawsuit within the appropriate form. As I mentioned, a supplier, you don't have to prove materials were incorporated into the job or even delivered to the job. You've just got to establish that you had a good faith belief, you furnished materials that were intended for a specified job pursuant to the governing prime contract. I always like to cite this case out of the Eastern District of Michigan, where a supplier's claim included material supplied after the job was certified as complete by the government. And the court said, given that contract work was certified as complete prior to any delivery of materials by the supplier, it's impossible for any of the materials to have been provided in prosecution of the prime contractual work. Good faith delivery is not a substitute for supplying materials in prosecution of work provided for in the contract. In other words, the materials still have to be provided in furtherance of the requirements of the prime contract. Here's a statute governing the notice of non-payment. And instead of reading it, what this statute says is if you're not in privity with the prime contractor, you're a second-tier sub, you must serve a notice of non-payment within 90 days of final furnishing. It should be served on the prime contractor and the surety if possible. Remember, if notice of non-payment not a requirement of first-tier subs or suppliers hired directly by the prime. A notice of non-payment needs to state with substantial accuracy the amount of the claim. Failure to do so can be fatal. I repeat, the notice of non-payment needs to be sent with, it needs to identify with substantial accuracy what you're actually claiming. In a case out of the Middle District of Louisiana, a second-tier sub, argued that their letter to a prime served as notice of non-payment. However, the letter never actually mentioned the sub or the specific amount it was owed. And the court held that they do not have any Miller Act payment bond rights because the notice of non-payment was not properly served. And it specifically did not identify with any substantial accuracy what the amount of the claim was. But here's another case out of the Middle District of Georgia, where a supplier notified the prime contractor and surety of the non-payment, but it only sent the notice of non-payment to the surety, not the prime contractor. The issue was whether the supplier properly served the notice of non-payment because the prime contractor did not receive it. And the court took a little more of a liberal spin. The purpose of the notice requirement of the Miller Act is to alert a general contractor that payment will be expected directly from him rather than from the subcontractor with whom the supplier dealt directly. The notice does not, however, have to be entirely in one writing for it to comply with the Miller Act. Written notice may be considered in conjunction with other writings or even oral statements to determine whether the general contractor was adequately informed, expressly or impliedly, that the supplier is looking to the general contractor for payment, so that it plainly appears that the nature and the state of the indebtedness was brought home to the general contractor. Ultimately, a party can rely on this and cobble together a bunch of documents, including one that identifies the amount of the claim, to make it a question of fact as to whether a notice of non-payment was properly served under the Miller Act, because it doesn't have to be in one particular writing. It's advantageous case for a second-tier sub or supplier. A sub's bankruptcy won't necessarily preclude a Miller Act payment bond claim by a second-tier sub. In other words, just because a sub filed for bankruptcy does not mean you don't have to properly preserve and pursue a Miller Act payment bond claim. In this case, a sub entered into an oral contract with a supplier. The supplier sued the sub for breach of contract and also sued the Miller Act payment bond claim. There was an evidentiary hearing in bankruptcy court to determine whether or not there was even a contract between the sub and the supplier, and if so, what the amount of that contract was. Bankruptcy court determined it, and some amount was paid from the sub's bankruptcy estate. The trial court, outside of the bankruptcy court, held that what a sub recovered in a bankruptcy proceeding will have no bearing on the merits or the legitimacy of the Miller Act payment bond lawsuit, other than perhaps serving as some contractual set-off based on the amount that the supplier recovered. Statute of limitations is 1 year from your final furnishing date. I apologize about that, the phone. Whatever you do, do not neglect to timely file a Miller Act payment bond lawsuit within 1 year from your final furnishing date. Doing so will be an absolute killer, as I'll discuss in a second. In this case, from the 11th Circuit, a sub sued a prime and recovered a judgment, but could not collect on the judgment. The sub then had the idea to sue the surety to collect on the judgment, but the statute of limitations had long expired. And the 11th Circuit affirmed, if you don't timely file your Miller Act payment bond lawsuit, you're dead in the water. There is a doctrine that parties sometimes try to use known as equitable tolling when they file a lawsuit against a Miller Act payment bond after the statute of limitations expired, i.e. after 1 year from their final furnishing date. This is an extremely challenging argument to actually support the merits of an equitable tolling claim. And I mean extremely challenging. And equitable tolling allows a federal court to toll a statute of limitations when a litigant's failure to meet a legally mandated deadline unavoidably arose from circumstances beyond a litigant's control. To determine whether equitable tolling applies, there are 5 factors that need to be established. The plaintiff's lack of notice of the filing requirement, the plaintiff's lack of constructive knowledge of the filing requirement, the plaintiff's diligence in pursuing her rights, an absence of prejudice to the defendant, and the plaintiff's reasonableness in remaining ignorant of the particular legal requirement. Here's the problem with an equitable tolling argument. Parties that typically are doing work on federal projects are considered sophisticated or more sophisticated, right? I mean, they've got to submit certified payroll in numerous instances. They're generally doing, work of a substantial dollar amount. As a result, there's generally no excuse for you not to know what your rights are under the Miller Act. And that will be held against a party when they try to argue equitable tolling should apply for whatever fact they're relying on to establish their argument as to why they couldn't timely file a lawsuit.
All right.
And here are...
Second, David, we got a question
Sure.
coming in here.
Sure.
Les is asking, if a contractor says they're a GC, but they find out a different GC is the one bonded on the job, can the letters be altered for the second round and notify the real GC? Or is the initial letter null at this point due to the wrong information on the first round?
Well, I'm not sure I completely understand that question. So if a party is notified that the wrong GC is serving as the prime contractor, I think we'd have to establish how that party was notified, right? So a first-tier sub is going to be in contractual privity with the actual prime contractor. So we're really talking about a second-tier party, and I think we'd have to understand exactly how that second tier does not know who the right prime contractor is. But in the event that because when it will matter the most is when they need to serve their notice of non-payment within 90 days from their final furnishing date. And at that point in time, presumably that party will have already requested a copy of the actual Miller Act payment bond, or should have a copy of that Miller Act payment bond that identifies the surety and the actual prime contractor. So more facts would have to be established to determine whether or not there's a basis to serve a late notice of non-payment, which I presume this is what this is referring to.
Yeah, so presumably you have the duty to figure it out and get your own copy of the bond claim to make sure that you get that the right person.
Copy of the bond claim where you have to establish why you served the notice of non-payment on the wrong general contractor. Because when you're serving the notice of non-payment, you're already done with your work. Right? So you've already done your work or supplied your materials over the course of the project. And now you're serving a notice of non-payment within 90 days of final furnishing because you haven't been paid.
Okay, and look, she's actually got a follow-up question here. She goes, as a supplier, if our customer is the one who's ordering the materials on the job and the material is delivered and the customer doesn't tell us of a different GC, we did not find out until after the letter had gone out, maybe it helps him to know that we're the supplier. I think this is kind of reiterating the fact that preliminary notices are always a good thing no matter what job you're on, so you can get informed as to who exactly the bonded GC is.
Yeah, so in that circumstance, I would absolutely at least preserve the argument by serving a proper notice of non-payment. But this goes to reinforce the point, perhaps I didn't make it as well as I should have early on, which is before you even get into a dispute on a federal project, you always want to get a copy of the Miller Act payment bond. You can request it from the prime contractor, you can request it from the government, from the contracting officer, so that you know exactly what your rights are and what you need to do and who you need to serve notice on before you're put in the situation where, oh my God, I'm coming upon the 90-day deadline, I'm required to serve a notice of non-payment. Who do I serve it on? In the situation that was the scenario that was just referenced, if you do serve it on the wrong GC, I would absolutely correct it and serve it on the correct prime contractor and their surety, if I know who the surety is, to at least create the argument that we served the notice of non-payment. If it was served on the wrong GC, but the right surety, then there's an argument that the GC still had notice of the claim with substantial accuracy.
Excellent.
I know we're coming upon time. These two cases really just are cases where a party tried to argue equitable tolling when they untimely filed the lawsuit, and courts were not buying the argument because, again, when you're doing federal work, you're presumed to be a little more sophisticated than perhaps other parties, so there's really no excuse not to know what your rights are and, frankly, not to timely preserve your rights.
We do have another question coming in. I believe it's somewhere along the lines of unapproved change orders. They're asking, how does the Miller Act apply to direction from the GC to proceed with furnishing additional materials relating to changes where no official changes were actually issued?
Okay, so if you're a subcontractor, by way of example, and you have a change order argument, I would always, as a first-tier sub, you don't have to serve a notice of non-payment, but I would always pursue a Miller Act payment bond claim for those amounts. There's no reason not to. There's even authority in certain jurisdictions where if you're remaining idle or we'll call them certain delay type damages, can be recovered against the Miller Act payment bond surety. That may not be universally applied in all jurisdictions, or all judicial circuits, I should say, federal circuits, but it is in some.
In your experience, have you had trouble trying to prove unapproved change orders?
No. So I've represented a number of subcontractors, including one right now, dealing in a Miller Act payment bond claim where we have a certain dollar amount for changes that are in dispute. And I won't have an issue establishing entitlement under the bond, but there could be an underlying contractual issue as it relates to the subcontract, which will still govern the entitlement to whether or not we'd be entitled to those amounts, right? So if the change order procedure or the requirement in the subcontract is not complied with, the surety and the prime contractor are going to be able to have that argument. They don't lose that argument simply because you're suing the surety. Mm-hmm. Does that make sense?
It does,
Hopefully.
absolutely. And we got another question here. If the party is providing rental equipment as well as materials that they've delivered, do they need to do two separate notices, or can they combine that into one notice of non-payment?
Well, if it's all under the same contract, then one. Right? If it's two separate contracts, I would certainly do two notices of non-payment, because you're doing two notices of non-payment under two separate agreements. So if you have one agreement where you're only furnishing rental equipment, and whether it be under an open account or some type of a rental agreement, and you have another agreement where you're also furnishing materials, then you're probably looking at two separate notices of non-payment. If it's all done under the same contract, then one notice of non-payment. You'd have to see how that agreement is structured with the subcontractor or supplier.
Perfect.
Venue. Excuse me. When you file a lawsuit against against the Miller Act payment bond, you file the lawsuit as the United States for the use and benefit of the claimant against the surety and perhaps the prime contractor, since it will be a principal of the bond. But it's always the United States for the use and benefit of X. X being the claimant. And you file it in the district in which the contract was to be performed and executed, which you can equate to where the project generally is located. So if you have a project in Maryland, that's going to be where the contract was to be performed and executed. And that's where you would file your lawsuit. But keep in mind that many contracts have what's called a form selection or a venue provision that says any and all lawsuits, brought under the arising out of or relating to this contract shall be exclusively brought in the jurisdiction of, I don't know, the Northern District of Alabama, by way of example. A prime contractor and a surety will have an argument to transfer venue based on the underlying form selection provision in your contract. And here are a couple of cases where sub sued a Miller Act payment bond surety and the prime where the project was located, which is really what you should do, because you're not filing a lawsuit in the wrong form. And the surety and the prime contract moved to transfer venue because there was a form selection provision in the subcontract. And federal courts will treat form selection provisions very seriously, simply because it's a negotiated provision that parties have agreed to on the front end. And although federal courts apply a different standard than most state courts do, the fact that parties negotiated a form selection provision is treated seriously. And in many instances, a court will transfer venue based on that form selection provision. Doesn't happen all the time, but it certainly happens. And they'll all cite to this Supreme Court case out of 2013, where the court said a district court should ordinarily transfer a case when parties have agreed to a form selection clause. There was a case that came out, 2 weeks ago, maybe even less, in where a project was located in Maryland and a subcontractor filed suit against the surety and the prime contractor in Maryland, right? Which was a proper district court under the Federal Miller Act. However, that same subcontractor agreed to a form selection provision in a district in Alabama. And as a result of the form selection provision being a negotiated clause, the court transferred it from the District Court of Maryland, which is also where the sub was located, all the way to Alabama, which was certainly not a convenient form for the sub, but the sub agreed to that on the front end. Sometimes if I'm dealing with that issue, or I think that issue could arise based on a bad form selection provision, I may try to water down the argument that I know will be forthcoming by not suing the prime contractor at all and only making a claim against the Miller Act payment bond surety. It doesn't mean that there won't be an argument to transfer venue, but because I'm not suing in a breach of contract or bringing in the actual prime contract, it could help to diminish that argument. The last thing, which is not part of the presentation, but I want to discuss, is under many state lien and bond law statutes, attorney's fees is simply a mechanism of the statute so that you can recover your attorney's fees in a lien foreclosure lawsuit or a payment bond lawsuit. The Miller Act, there is no statutory basis to recover your fees. So just because you prevail on a Miller Act payment bond claim does not mean you get your fees. In order to get your fees, it's going to vary based on the circuit you're in. For example, within the 11th Circuit, in order to recover your fees under the Miller Act payment bond, you have to have an underlying contractual basis. So if there's a basis in your contract to recover attorney's fees, then there's a strong argument you'll be able to recover your attorney's fees against the bond. If there's no contractual basis, you will not get your fees, absent you having another, perhaps a statutory argument to recover your fees. That's within the 11th Circuit. Other circuits treat attorney's fees differently. That's really the nuts and bolts of a Miller Act payment bond claim. If I could, give a few takeaways to sum up kind of the presentation, would be number one, if you're doing federal work, you want to know on the front end whether you have Miller Act payment bond rights. So if you're third tier, you know you're not going to have Miller Act payment bond rights. If you're second tier, you know you will. Second, you want to know whether or not you will need to serve a notice of non-payment if you are not paid to maximize your recovery against the bond. Remember, if you're first tier, you don't have to serve a notice of non-payment. If you're second tier, you absolutely do need to serve a notice of non-payment. Third, if you're required to serve a notice of non-payment, you want to make sure you're serving it on the prime contractor, and if you can, the surety as well, and you want to identify your claim amount with substantial accuracy. So don't just say you're owed money, say I'm owed 150 grand under this contract, right? Substantial accuracy means exactly what it says in the Miller Act. And the last takeaway, probably should have been the first takeaway, is if you're doing work on a federal project, there's nothing that should preclude you from requesting a copy of the Miller Act payment bond on the front end. In representing prime contractors that do federal work, I've never had a prime contractor client refuse to provide the Miller Act payment bond, because the prime contractor knows that that entity can simply go to, at some point, the government and request it directly. And they'd rather, in my experience, they'd rather control that process. But if you don't get it from the prime, you can always get it from the contracting officer. You can ask, or if you have trouble locating the contracting officer, you can always fill out an affidavit and send it to the department, the head of the department, and you'll get it there.
All right, well, I think we're just about out of time. David, I want to thank you for taking your time out today to come help us. I hope everyone thought this was as informative as I did. If you guys have any further questions, feel free to hop on the Expert Center. We got a link in it down in the description below. Or you can reach out to David personally. We have all his contact information on his Expert Center profile. So thanks again, y'all, and you guys have a good day.
Thanks, Alex.